Good morning, everyone. Thanks for joining us. We're going to give everybody a few minutes to get in, and then we'll begin at 10. Good morning, everyone. Thank you for joining us. We still have a few people coming on, but we're going to go ahead and get started. Thanks for being here with us today for a great session on trademarking for food and farm businesses with Leo John from the North Carolina Secretary of State's office. These are hosted by the NC Growing Together project, which we'll talk about in a minute. And we want to give a big thank you to our co-sponsors at the North Carolina Rural Center for helping us host this event and all of the others in this series. Just one more moment. And we'll be ready to go. All right. So I'm going to give you a very quick introduction to this webinar platform. We'll have our presentation, and then we will do questions and answers at the end, and I'll show you shortly how to ask those questions to the presenter. The North Carolina Growing Together project hosts these as part of our 5-year USDA-funded project aimed at moving more local and regional products into mainstream markets. The fourth bullet that we work on of creating supportive business environments means that we get to work with a lot of small business centers, local and regional governments around the state, and our Cooperative Extension partners to help businesses overcome obstacles to entering some of the larger markets that they have. So this series is designed as part of that to help both food and farm businesses and those that that work with them have the resources that they need to move forward and expand their products and their markets. The GoToWebinar platform automatically mutes you as an attendee. You can ask a question using the questions box over on the right-hand side. You can also, if you see your own name under attendees, click the little question mark button, and it will help you ask a question. If you have difficulties during the broadcast, please find my name under staff, Emily Edmonds, and right-click to send me a private message, and I will do what I can to help you. You will note also on the right sidebar, second from the bottom, there is a handout that you can download. That is today's slide. It has all the links that you'll need to follow through with the webinar or to follow up on things afterwards. As you send questions, I will let them panelists know as they come in if it works for the presenter, and if not, we will hold them until the end and answer them then. When the webinar ends today or tomorrow, you will receive a follow-up email that will have the PDF version of the presentation as well as a link to the YouTube recording. And if you have ideas for future sessions, we'll talk a little bit later about one more webinar that we have coming up in the 2017 series, and then we'll be designing a new series for next year. So we'd be very open to your ideas and suggestions for topics you'd be interested in learning more about. And with that said, I'm going to turn things over to Leo John and let him introduce himself to you, and he will take things from here.
Great. Good morning, Emily. Good morning, everybody, and thanks for joining in on this, what I think is a very interesting webinar on trademarks. Before I start, I just want to personally thank both Emily as well as Delisha over at the North Carolina Rural Center, who've been very helpful in putting these. We've done one before in putting these webinars together, because this is really a very efficient way of getting some very important education out to the people who interact most with small businesses, the small business centers, the extension centers, and you day in and day out talk to the small businesses who we are really trying to service and help. And so, putting this webinar together has been a great idea, and I want to personally thank both of you for your help in doing this. So what are we going to talk about today? So this, to me, is a topic, trademarks is a topic on which I probably get the most number of questions. So let me just tell you briefly my role. So I work at the North Carolina Secretary of State's office. I was doing until Friday investor and business outreach for the agency, essentially providing some education around issues facing small businesses, trademarks, incorporation, securities and crowdfunding. And starting yesterday, I sort of moved into a slightly different role around policy and working more with the legislature on things. But this particular topic is a topic on which I get a lot of questions, and it seems to draw a lot of interest because I think in the modern economy, the economy that we are thriving in right now, the trademark and all of the intellectual property has become such a crucial element for all kinds of businesses, both big and small. So let me start with the very first slide, which is really for somebody who knows nothing about trademarks and you just heard the word and you don't really know what it means. This is what a trademark is, right? These are the sort of examples of a kind of modern currency, right? It's the logos, it's the brands, it's the names of companies and products that we're all familiar with, and we've all grown to love or hate depending on kind of our experience with each of these. So, for example, you know, the one that I like to throw out there because it was very personal to me is the Golden Arches, right? So I spent a lot of time on 40 east and west, going up and down, sort of going to various small business centers and other locations. And as I was driving down, the one logo that I see a lot of was the Golden Arches, right? And as soon as I saw that, I had an immediate reaction, which was I began to get hungry. Well, for some other people, the reaction is disgust, maybe, for people who don't like fast food. But nobody has to stop me and explain to me sort of what I'm going to get at the Golden Arches, right? I know what I'm going to get without stopping, without getting off the ramp, without going in and talking to a customer service person, asking for the menu. I know immediately if I were to stop and get something to eat, this is what I would get. That immediate brand recognition, that immediate sort of brand loyalty that you get from customers is kind of the value of the trademark, right? So if you think about the Mickey Mouse logo, for example, you see that and immediately brings back memories for you of maybe times that you've spent with your family, or good times or vacations, that kind of thing. And so the point is, all these are examples of federal trademarks. These are brands and logos that we've all grown to love. The federal trademarks process, and this might be a good time to point out a distinction. The federal trademarks process is managed by the U.S. Patent and Trademark Office out of Washington, D.C. Some of you who maybe have interacted with the trademarks process may know that this is an expensive process. It can cost several thousands of dollars depending on what kind of trademark and how many categories of industries you want to cover. It could also be a lengthy process. It can take several months for you to get a trademark at the federal level, and it's not something that you do kind of on a whim, right? For companies that maybe are not as let's say ambitious, or companies that are not as global, each state also has its own state trademark process. And I think this is something that not very many people know about, and honestly, I didn't know about it until I kind of got into this area. But it's really kind of an option for small businesses that maybe operate within a state. So if you think about, a lot of small restaurants or breweries or food businesses, they don't really operate across state lines. A lot of them have sort of one location or two locations, maybe in two different counties within the state of North Carolina. And in that instance, it's worth considering whether that small business needs to get a federal trademark with all the costs and the time involved, or if that small business should consider maybe a state level trademark, which gives them the same amount of intellectual property protection, except that it is within the state lines. So that's a crucial distinction that if you're talking to a small business, you need to explain to them that if they're getting a state trademark, their intellectual property is protected within the borders of the state. It doesn't travel across state lines. So what are some trademarks? So these are, if you look at the slide in front of you, these are some of the trademarks that we've awarded at the state level. And most of you are probably familiar with the Panthers. Those of you who maybe have visited Raleigh or been to Raleigh are probably familiar with the Angus Barn, the famous venerable restaurant off Glenwood Avenue. Bojangles, of course, and Cheerwine statewide chains, or products that are famous across the state. And of course, there's the car dealership Crossroads Cars. So these are all examples of state-level trademarks. These are brands, these are logos, and these are names that we're all familiar with, we like, and that have a tremendous amount of value. The question maybe for an Angus barn may have been, do they operate in more than one state? Do they need to go and get a state or a federal trademark, or are they okay with a state level trademark? So those are sort of two distinct paths that you as a small business can take. You can go down the federal path, or you can take the state path, or you can actually do both. So there's really three different ways to do it. So what are trademarks? So let's put it in the context of where trademarks fit. So trademarks are just one example of what is generally called intellectual property, right? So this is kind of the intangible, the sort of out there in the air sort of property that a business may own, that you cannot really touch, you cannot really feel it, you cannot really move it, something that's physical, but it's still valuable. It's a kind of property that in the modern economy has a lot of currency for a small business. So the definition of intellectual property is really any idea, invention, or process that derives from the work of the mind or intellect. So this is what we're talking about. We're talking about something that's intangible, something that it still has a tremendous amount of value. It gives the owners the right to the exclusive use and protection of its brands, of its brand of goods and services. Trademarks are just one type of intellectual property. There are, of course, several different types of IP. Patents, probably the most important, probably the sort of the highest value IP that businesses own. It's really awarded for a new invention, a new design, something innovative that somebody has come up with as a way to solve the problem or to come up with a better product. And these patents are typically protected by by filing with the U.S. Patent and Trademarks Office out of Washington, D.C. Another type of intellectual property are copyrights, right? These are sort of the rights to a movie, a song, a book, some kind of creative product that somebody has come up with. And the way to obtain intellectual property with copyrights is, of course, to file for copyright protection with the Library of Congress in Washington, D.C. We at the state level do not have anything to do with patents and copyrights, which is why we will only be talking about trademarks today. Another type of intellectual property, and sometimes people get confused between this and trademarks, but another type of IP is what's called trade secrets. So the example that I like to use here, and probably one that you've heard at some point, is kind of the secret recipe for Coca-Cola, right? So as I as I tell people, if any of you know the recipe to Coca-Cola, please reach out to me privately through a secret message or any other email or any form you want. I'm happy to come meet with you, take you to lunch, and we can talk about this recipe that you have, because I can tell you that would be very valuable information in the marketplace. As you might imagine, Coca-Cola keeps its recipe secret. For those of you who heard, they have a vault out in Atlanta. There's probably 4 or 5 people that know kind of what that secret formula is. And when one of them passes away, they probably bring in sort of one other person to share that secret. So it's kind of a very valuable thing for that particular company. And as you think about your own companies, if you're coming up with a sauce or a type of food product that you're selling, and if you think there is something special about it, there's some kind of secret to it that you don't want everybody to know, you should probably think about protecting it as a trade secret. Trade secrets are not filed anywhere. They are essentially a business has to create a trade secret program for itself, meaning you work with your attorney or you work with sort of an advisor to essentially keep that information secret from everybody else because you see commercial value in there. So this is not something that you would necessarily file with a government agency. The IP, the type of intellectual property that we're going to talk about, are essentially 2 things, and they're used interchangeably, and they mean the same thing, but they get different names. One is, of course, the trademark, and the other is the service mark. These are both, they cover or they provide the same amount of rights, same types of rights. The only difference between a trademark and a service mark is that a trademark covers products. So if you can touch, if you can feel something, if you can pick it up, move it around, you probably have a product. If it is a service that you provide, it's accounting services, tax preparation services. Even if you're selling food at a restaurant, that may be restaurant services. Those are examples of a type of intellectual property that would cover those services, and those are called service marks. Again, there's no difference in the rights you get. They're just called different things because they cover different types of property. So what is a trademark? Well, the statutory definition of a trademark is it's a word, name, symbol, or device, or any combination thereof, adopted and used by a person for 2 reasons. And this is, if you understand these 2, I think it'll help you sort of guide yourself through this whole trademarks maze. So the 2 purposes of trademarks are, number 1, to identify the goods made, and number 2, to distinguish the goods from those of others. So number 1, it gives the person who created the product, the inventor or the person who came up with the name or the brand or the logo, the rights to the product, as they should, right? I mean, you've come up with something new, you've used your creative power to come up with a logo. You should have the rights to that particular name or brand. The other purpose to trademarks is from the point of view of the customer. As you might imagine, a customer in today's economy gets bombarded with various products, various names, various brands, and sometimes it could be confusing for a customer to figure out, what level of service am I going to get? What is the quality of this product? That is where a trademarked brand or service, product or service, comes in, because now the customer can be certain that they're going to get a particular level of or a particular quality of product. So if you think back to my example of walking down, going down 40 and stopping at McDonald's, well, I know what I'm going to get as a customer at McDonald's. I know what I'm going to get in terms of the menu, in terms of the quality of food. I'm not going going to be confused if I walk into a, I don't know, Hardee's or Burger King, because I expect different products and different quality, or different variety of foods that I could get there versus going to a McDonald's. So if you look at it from the point of view of the person who comes up with the name and the customer, then it'll sort of help guide you through the process. As I said, the service mark is essentially the same thing, except that it covers services. So here, the next few slides, I try and give you kind of a very simple example of maybe how this all plays out and why trademarks matter in kind of the grand scheme of things. And you've probably seen examples of this or these kinds of examples all the time. But say we're of course in North Carolina, a big barbecue state. There's kind of the Eastern barbecue and the Western barbecue, and the whole heritage and the history of barbecue is kind of a big deal in North Carolina. So let's say one of us comes up with a barbecue sauce. This is something delicious. The inventor shares it with friends and family, and they said, you should sell this. This is a commercially viable product that's probably going to have a lot of demand. So of course you got to call the sauce something. So let's say you call it the lip smacking barbecue sauce. Okay, so that's the name you come up with. But you're clever, right? You don't want to just call it lip smacking. You give it a little twist. So you get rid of the G and you put an apostrophe at the end. So now you got the lip smacking, cool sounding name, barbecue sauce, right? This sauce is now being sold commercially. Let's say you start a restaurant, right? You take this the sauce, and now you're putting it out there in a restaurant. The restaurant does really well, right? You've got all these people that are waiting in line that want to get into this restaurant because, well, this is some delicious barbecue sauce. A lot of people are watching your restaurant. Okay, they see your success. And some of them may not necessarily have your best interests at heart, but they also want to get into that space. So say a competitor finds a nearby space, maybe in the same block, maybe a couple of blocks down the road, and they start another restaurant. This time they call it the plain old lip smacking barbecue sauce restaurant, right? So they've put back the G, they've gotten rid of the apostrophe. Now you've got two very similar sounding restaurants. And if you think back to what a customer is going to expect, they both sound the same to the customer. The impact on the customer is, of course, that a lot of them begin to go to your competitor's restaurant versus yours. The lines all shift to your competitor's restaurant. And this means, of course, that your restaurant ends up losing a lot of business. Now, this is a little bit of an extreme example. It might even be a little silly, but I think it illustrates the point in that if you do not take that extra step of protecting your name or your brand, and if you have a lot of value attached to that name or brand, then you may be doing yourself a disservice, because now somebody else could step in there and take advantage of sort of your popularity or your product's appeal to a large section of consumers. So that's why I guess a trademark is important in kind of the modern economy. So again, what is a trademark? Well, a trademark is any word, name, symbol, or device, or any combination thereof used by a person to identify the goods made and to distinguish them from others. In North Carolina, how do you get a trademark? At the state level, you can obtain a trademark very easily, actually. Of course, assuming that you meet all the requirements. You simply have to file a form, which is available on our website at www.sosnc.gov. You file a form, which is an application for a trademark. you provide a filing fee of $75 for each trademark that you're trying to obtain, and you provide 3 specimens of the mark as it's being used in commerce today, and you provide those to the Secretary of State's office. Your trademark registration is effective for 10 years. After 5 years, we will send you a letter and we'll ask you, are you still using that trademark? If you don't respond, or you respond and you say you're not using it, then of course your trademark lapses. But if you do respond and you provide examples of the mark as it's being used, then it's renewable for another 5 years, and then for successive terms of 10 years, really in perpetuity. So you could have a trademark and sort of keep it forever, or at least as long as you're actually using that trademark in commerce. So I just want to sort of drift back to the question of why do you need a trademark? What are the benefits? Because I think a lot of people don't appreciate the importance of trademarks in the modern economy. So it does several things. Number one, it protects the brand. As you think back to the lip smacking barbecue example, you are now protected. You own that brand. And it's important because you may have spent a lot of time and effort in coming up with that name or brand. In many cases, people hire advertising agencies or marketing companies to come up with these names and brands. And if you've done that and you've spent a lot of money, you might want to consider protecting that investment that you made. The other thing a trademark does, it protects the quality of the goods and services. Now, how does it do that? From the point of view of the customer, this is important because only a person who controls the making of the product can get a trademark on that product. So what does that mean? Well, if you outsource all of the manufacturing of a particular product, the design, the sales, the inventory management, the logistics, and you simply sort of sit there and count the money, for lack of a better phrase, then essentially you are not controlling the making of the product. And in that case, it's going to be hard for you to get a trademark on that particular product. So from the point of view of the customer, well, they can now begin to expect a certain level of quality because the person that's making the product is actually the one that owns the trademark to it. Now, of course, again, in the modern economy, no company does everything. They typically outsource some parts of every manufacturing process. However, the majority of the control, if you have no control or if you have very little control, it may be hard for you to get a trademark. So it protects the consumer from that point of view. The third benefit of a trademark, and again, this is sometimes lost to small business owners, is that a trademark can be valuable financial capital for your business. It is valued by outside investors. It is valued by anybody who comes in and wants to buy your company. This would all be IP. It would be intellectual property that you can put a monetary value on. And if you're selling your company or you're trying to sell your product, you can add the value of this IP to your balance sheet. If you look at the balance sheets of some of the major corporations in the country, we're talking about kind of the Fortune 500 companies, you will see that in many cases, the value of the intellectual property, the patents, the trademarks, etc., is sometimes even greater than the value of the hard assets of the company. So think about that for a second. You're talking about this fictional, intangible IP that a company owns that may be more than, or that may be worth more than the hard assets, the building, the inventory, the actual products that the company makes, which is a significant value for you as a business in many instances. Okay, so the North Carolina Trademark Act. So this is the statute under which all of our rules and the processes work. So the purpose of the act is essentially to provide a system of state trademark registration. Uh, and our directive as a state agency is to read this statute and to read the rules associated with the statute in tandem with the federal rules that govern this process. So the federal U.S. Patent and Trademark Office has a set of interpretive guidelines on how to read particular rules, and our directive is to basically, read our rules in tandem with those federal rules on trademarks. Okay, so when you file for a trademark, remember you fill out a form, you attach a check for $75, and you provide 3 specimens of the mark, and you submit that to us as a state agency. What do we do with it, with that particular form and application? What we do is we essentially search 3 databases. Our effort is essentially to follow our legal directive, which is to make sure that there is no same or similar name or same or similar mark that has been registered to somebody else. So our goal when we get the form is to make sure we search these 3 databases, and if you do not have a same or similar name as an existing mark, then you may be able to get a trademark for your particular name. So what are the 3 databases that we search? Well, the first database we look at is the existing trademark database, which is on the North Carolina Secretary of State's office, sosnc.gov. It is, by the way, a public, free, searchable database. In fact, it's even searchable by county. So if you go to our website, you can do the search yourself before you submit your application to us. But that is the first database we are looking for. Again, we're looking for same or similar names as the one that you are submitting to get registered. The other database, the second database we look at is the North Carolina Corporations database. As you may know, Secretary of State registers all business entities in North Carolina. So this includes LLCs, corporations, limited partnerships, any other type of legal entity that is registered in the state is registered with us. So when we get an application for a trademark, we will look for a same or similar name for a corporation, LLC, any other type of entity that may be registered with us. The third database that we would look at is the federal trademarks database. Again, this database is maintained by the U.S. Patent and Trademark Office out of Washington, D.C. What we're looking for is to see whether there is a North Carolina corporation that has, or North Carolina business entity that has a same or similar name as the one that you may be seeking. So an important point to make here is the name that you come up with may not be similar to any existing North Carolina corporation, but it may be similar to an existing federal trademark that has, say, been awarded to a company in California. If that is the case, then you may be able to get your trademark at the state level in North Carolina. However, if there is a North Carolina entity that has obtained a federal trademark, which is same or similar to what is the mark that you are trying to obtain, you may not be able to get your trademark. And that, of course, begs the question, why? The easy way to think about it is, again, from the point of view of, say, a lip-smacking barbecue restaurant in North Carolina. Well, who are their competitors? All the competitors for lip-smacking barbecue restaurant in Wake County are going to be other Wake County restaurants. At the most, they may be, nearby counties, nearby cities or towns. It's unlikely to be, the competitor is unlikely to be a restaurant in California, because a customer who wants to go to a barbecue restaurant is not going to choose between lip smacking in Wake County and a barbecue restaurant in California. They're going to be choosing between restaurants around them. So from the point of view of customer confusion, that is not as much of a problem. And from the point of view of competitors for the restaurant also, other state trademarks are not as much of an issue. So that's kind of why the North Carolina Trademarks database, or the North Carolina companies that have filed for trademarks at the federal level from North Carolina are probably seen as kind of more of an issue for a local company. Okay, so this next slide talks about two concepts, and this is again sometimes confused by folks in the business. One is the idea of a trade name, and the other is the idea of a trademark. So they're two totally different things. Well, not totally different, but they're different things. The trade name is essentially what is sometimes called a DBA, or an assumed name. So as many of you may know, if a business or an individual is operating using a name other than their own, then they're required to register that name with the Register of Deeds office in every county that they're doing business. So that, of course, means if you're a sole proprietorship and you're doing business in 5 different counties, well, you're required to register that name in those 5 counties in the state. Now, that is an assumed name. That is a DBA that you're operating under. That is registering that name simply does that. It registers your name in a database that's maintained by the Register of Deeds office in that county. Now we're slowly moving to a more centralized system where those names are going to be registered at the state level with the Secretary of State's office. But that's a process in transition. However, it does not give you any additional legal rights. It does not give you sort of any trademark rights. That is simply a registry of the name that you're operating under. A trademark, on the other hand, gives you a legal right to that particular name, brand, or logo that you've come up with. So if somebody else tries to use that same name that you've trademarked, you may have a legal case against that particular person. So it gives you additional legal rights that may not necessarily come with having a trade name. Okay, so the next slide, I call it concepts and trademarks because I think this is an area where sometimes there's a lot of confusion. Let me just raise the first issue, which is descriptive terms. So often we'll get applications from businesses that call themselves the best homemade barbecue sauce. Now, if you use that particular slogan in a logo and the whole thing is trademarked, well, now that particular slogan may be part of the logo. And if that logo is not same or similar to an existing trademark, you may be able to trademark that entire thing. In most cases, when people try to register their slogan, they're registering that particular slogan separately from a logo. So they're saying, well, we call our sauce the best homemade barbecue sauce. Well, in those cases, the terms best, homemade, those all may be seen as simply descriptive terms. There may be nothing unique about that particular term, that particular adjective that you've used, but it simply describes your product. And so it may be harder for you to get a trademark on that particular term. Now, it's possible to get a trademark on anything unique that you've come up with, but if you're simply using a term to describe your product, it may be harder for you to register that as a trademark. What does the word commercial use mean? So if you think back to when you submit your trademark application, you've got to submit 3 specimens of your mark as it's being used, meaning you cannot just set up a website and say I plan to sell, I don't know, I plan to sell, breakfast bars under this particular name. I have not sold a single breakfast bar. In fact, I don't even have a checkout counter. I don't have a way to collect payments, but I plan to sell granola bars under this particular name. Well, then you're not actually using that name in commerce. It's something you're planning to use in commerce. In North Carolina, it's going to be hard for you to get in advance of use trademarks. Now, at the federal level, there is a way to get a trademark in advance of actual use, and I would encourage you to talk to an attorney about that process. But at the state level, you have to have that product in use, being sold, before you can actually get a trademark. The next point I want to make is the lesson we've all learned from the trademark related to OBX. So some of you may know OBX, of course, stands for the Outer Banks. And in North Carolina, the Outer Bank or the OBX term has a sort of an important trademarks history associated with it. And what is that? Well, the person who came up with the term OBX first began using it, got it trademarked, and the trademark was in existence when other stores and nearby vendors began selling products under the name OBX. Our trademark's owner knew about it, did not do anything about it. The term got so used and so widely used that it almost became generic to, as it's used today, a way to describe the Outer Banks. Well, at some point, many years after the trademark had been obtained and the owner had known that other people were using the trademark owner suddenly woke up one day and filed lawsuits against people that were using the OBX term. They, of course, fought back, saying, OBX was simply a way to describe the Outer Banks, and there was no sort of exclusive rights associated with that term. However, the person did own a trademark on it, and so, of course, it went to court. It went all the way up to the Fourth Circuit Appeals Court, and the High Court decided that now that this term had become so widely and generically known to describe a particular location, there may not be any exclusive ownership rights associated with that. So this owner, the person who had the trademark, had essentially given up the rights to that particular term, that particular phrase, because he had not taken any steps to protect that trademark. So the lesson for all of us in North Carolina, small business owners and such, is if you own a trademark, then make sure you protect it. So if you don't protect it, then a court, a state agency, or somebody else is unlikely to protect it. So there are various ways you can do it. You can certainly, at the first instance of seeing somebody abusing your rights, you should notify them. You should probably hire an attorney and file a cease and desist. At minimum, if you're not intent on getting into confrontations, you can certainly enter into a license agreement with somebody that wants to use your phrase or name, and essentially come to an agreement where they can use the name as long as they pay you particular royalties, or they only use it within particular geography or only for a particular product. You can determine what those rights are, but you've got to sort of take proactive steps to protect your brand name. If you don't do that, you may then set yourself up for sort of a point where you may not be able to get some outside or court assistance to protect your trademark. So when you're filing for a trademark, you have to provide 3 specimens. Okay, so what are specimens? Well, applicants are required to submit 3 complete, original, and current, meaning not more than 6 months old, specimens of the mark as it's currently being used. So if you've not sold your product for the past 6 months, or you've at some point had a business, it's basically gone dormant for the past 6 months, then you might not be able to obtain a trademark because, again, it's not current. It has to be an original. So let me move to the next slide, because here it provides some examples of appropriate specimens for marks. So let's see. I was looking for. Okay, so this is the next slide, and it gives you actual examples. The second from the bottom, for all of you that run food businesses, you can use menus and napkins and matchbooks, which are used in your restaurants where your mark is displayed. So if your logo is on your menu, or your name of your restaurant is on your menu, those are all perfectly good examples of the mark, as they're being used currently in commerce. But what are some examples? Well, you can send us your product itself with the mark. This is not a preferred type of specimen. In fact, our office proactively tells people not to send their products because it's just cumbersome and it just ends up in the trash. So you can send us a photograph of the mark as it's being used, right? So if you've got a product and you got the logo stamped on it, you can send us a photograph, a clear photograph. You can send us catalogs. You can send us a display, meaning you can step outside your store, take a picture of your storefront with your name emblazoned on the top. Those would all be examples. A web page printout, those are all perfectly good specimens. Any advertisements that you've used, if you've got advertisements with your logo on it, those are perfectly good. Billboards, outside shots of buildings, all those are perfectly good specimens of the mark as they're being used. What are unacceptable specimens? So they have to be original, they have to be current. So blueprints are just that. They're blueprints. They're plans for future use. They're not current. They're often not what's actually happening today. Drawings, similarly. Photocopies are not okay because they're not originals. Faxes, voided checks are not acceptable. And the last one is photographs of clothing, because in many instances the clothing are just accessories, sort of a way to brand your business, but it's not really the product that you're selling. So it could be sort of freebie that you offer your customers, but it's not really your product. It's not really the product that you're selling. It's just sort of something on the side that you give customers. So it's going to be harder to show that as an example of your commercial use of your particular trademark. So if you get a trademark, you have certain rights, chief among which is you can go to the courts to enforce your trademark. So there are civil remedies and there are criminal penalties for anybody who counterfeits, copies, or imitates a mark. Our office has a criminal enforcement division for trademarks. As you might imagine, there are many flea markets and such where you can see sort of fake Prada purses and Gucci bags that are being offered and sold. And our agents are out there sort of ferreting these guys out and confiscating these kind of products. If you are aware of such any such instances, also please let us know. We have a lot of material available online. Trademarks, is an area where you can do a lot of research in advance of submitting any application. There are FAQs, the database is available, it's searchable, and of course, there are things you can do with a trademark that may be useful in sort of a transactional sense, in that if you sell your business or your product, you can assign your trademark to another owner. So you can essentially hand over your rights to a particular trademark to a third party. To do that, you've got to file a form, you've got to submit essentially an application saying I'm assigning my mark to somebody else, and there are fees associated with all of that. It's available online too. Okay, almost there. Yes, so this is our phone number for Deborah Butler. She is the trademarks registrar in North Carolina. She is extremely helpful, very knowledgeable, and is very willing to sort of answer specific questions. As you can imagine, she is one of I think we have a staff of 1.5 that actually do the registration of trademarks. So as you can imagine, she's extremely busy, but she's also very helpful, especially to small businesses that need help with these kind of filings. So our phone numbers are, her phone number is listed. We'd encourage you to pick up the phone and call. And if you have general questions, of course, you can call the general number. But we really want to be helpful in this space. And I think that is it, if I'm not mistaken, Emily. Happy to hand it over to you.
Excellent. Thank you so much, Leo. That was really informative. And we're so glad that you take the time to walk us through these topics on behalf of the Secretary of State's office. We really appreciate it. If you guys have questions, feel free to send them in right now. I don't have any that are pending. I do want to make sure that you're aware our last webinar of the 2017 series is coming up on November 13th. Excuse me. That features local food and culinary programs at community colleges with Central Carolina Community College and AB Tech Community College. That registration is available on our website that you'll see right there at the bottom, ncgrowingtogether.org. Just click on events and scroll down till you see it. And then if you have suggestions for future webinar topics for 2018, we'll be running 2 of those next year, one for small business development centers and one for local and regional governments. And we are more than happy to have your suggestions incorporated as we start the planning process. My email address is right there. Feel free to send those to me as you get them. If we don't have any questions coming in, we'll go ahead and wrap things up, and we will be sending this out to you and posting it on YouTube within the next couple of business days. Leo, thank you again so much for your time. Jaleisha at the Rural Center, thank you as well. And we look forward to seeing you guys again on November 13th. Thank you.
Thanks a lot. Bye.
Thanks, Leo. Bye-bye.